we have 2 bills left, and because Senator Wojtkowski has been here the longest besides me, I'm going to hand him the gavel. All right.
9:30, all right.
That's right. I don't know if that's a punishment or
we have bills on policy.
We're turning our attention to item number 16 regarding gender wage differentials. This is SB 358. I see your witnesses are assembled.
They are indeed. Thank you, Mr. Chair, members. This is SB 358, which will revise California's Equal Pay Act. I accept the amendments represented in the mock-up that you have before you, and I could go through in great detail the fact that we have a significant gender gap in the state, women making 84 cents for every dollar a white man makes, African-American women 58 cents, and Latinas 44 cents. This wage gap, as I mentioned, just extends far and wide into almost all occupations, and the biggest gap being for our women of color. We have had in law a prohibition against gender-based discrimination since 1949, and yet we still have a significant problem. The state provisions, which are based on the Federal Equal Pay Act, are rarely utilized because many loopholes make it nearly impossible to establish a successful claim. The mock-up amendments that you have represent negotiations that we've had with the California Chamber of Commerce and the Civil Justice Association. I want to thank them. They have worked very hard. We're very close to an agreement here. I'm hoping that that happens. I think it's very likely. We've just got one small concern now. But this bill is going to help to close the wage gap in several important ways. First, the employee will no longer face retaliation by her employer for asking about the wages being paid to other employees. You can't know you're being discriminated against if you can't know what other people are making. And there is that fear of retaliation today, which makes that impossible. So second, this bill will go steps further than current federal law in its powerful combination of additional provisions ensuring that workers can challenge pay discrimination based on wages paid to other workers at different work sites of the same employer. Example, a grocery checkout clerk who works at a store in West Sacramento could challenge the higher wages being paid to the grocery checkout clerks who are of the opposite sex and working in the grocery chain's Natomas location. Why should that pay differential take place? Workers can challenge pay discrimination based on wages paid to workers doing substantially similar work. Example, a female housekeeper who provides room cleaning services at a hotel could challenge the higher wages being paid to the male janitor who cleans the lobby and the banquet halls. This is the kind of discrimination that we are confronting. Employers would be required to show that a difference in wages is based on a specific factor that is legitimate, serves a business purpose, and is not based or derived from a gender bias. In other words, it's got to be a gender-blind distinction. So we have, as I said, moved forward. We are working with the Chamber. This is a bill that is just going to bring us to parity, finally, once and for all, while allowing differentials that are not gender-based. And there are some of those. It's employment, experience, potentially work history, education. These are legitimate concerns, but we need to make sure that when we're paying people, they are being paid on a gender-blind basis. And I have here as a witness a wonderful woman who testified for us last week, demonstrating there's absolutely no reasonable basis for being paid less. So with that, Eileen Rizzo, who will give us a firsthand account of continued wage discrimination. And then we also have Marissa Diaz with Equal Rights Advocates who are helping with this bill. And we've been working on this for a mere 35 years. It's about time.
Good evening, members of the committee. Thank you for this opportunity to share my story. My name is Eileen Rizzo, and I'm the mother of 3 daughters and the sole breadwinner of my household. I've worked in math education for approximately 19 years, and I have 2 master's degrees, one in educational technology and one in math education. My professional title is math consultant, and I work for the Fresno County Office of Education, which is under the leadership of Superintendent Jim Yavino. In July 2012, after about 3 years with the county office, I was in my 4th year. One of my colleagues who has just signed his first contract shared how he was signed at a salary step that would grant him thousands more than I was making and nearly 20,000 more than I was given on my first contract. This made no sense for 3 important reasons. I had more experience, more education, and more seniority. As the other males shared their salaries, it quickly became apparent that as the only full-time female in the math department, I was the only one who, when hired, was placed at the lowest point of the salary scale. I was humiliated, embarrassed, and ashamed. The next week, I met with the HR administrator. She explained that the institution solely used prior pay to base my salary. I tried to explain how such a policy allowed for discrimination and only perpetuated the wage gap. I wish I could tell you that after that conversation, everything was set right and the policy was revised, but that is far from the journey that I have taken since then. After a month of waiting for a reply, I received a letter that in essence said, "We know you feel slighted, but we're standing by our policy." I appealed to higher administration and even Jim Yovino as a newly elected superintendent, but all of it came to nothing. With all my internal efforts exhausted, I felt defeated. When I decided to get a lawyer, I had no idea how long it would take or how much we would invest both emotionally and financially. It took 6 months alone to obtain the right to sue from the Department of Justice. And if we win summary judgment, the protected trial date is not until January 2016. My parents sacrificed so that I could be the first to go to college. I paid the same tuition as the males around me, yet statistics show that right out of college, women are earning less. Many would say that we do not need more laws, but I am grateful for laws like the Equal Pay Act, without which I would never have had the opportunity to fight this discrimination that I'm experiencing. No one would prefer the path of a lawsuit and the drain that it takes to stand up to institutions that have deeper pockets and that have no urgency to resolve the issue for which they have no emotional tie. Many women like me work years without knowing that the man they sit next to is taking more money home to his family, and my family is worth just the same as his. My story is not over. Every day I go to work and I expose myself to the twist of the discrimination knife, praise for work well done, requests for work that I am more highly skilled to do, and even praise for the work that I've done statewide is all tainted because my employer continually decides to pay me less than my male counterparts, and I can never make up for those wages that I have lost or for the retirement that I have lost.
Thank you. Next witness.
Hello, good evening. My name is Marisa Diaz. I work at Equal Rights Advocates, one of the organizational co-sponsors of this bill. ERA, over its more than 40-year history, has represented women, hundreds of women seeking fair pay in a wide variety of industries. We know that women's earnings are even more essential to families, their communities, and the economy of California now than ever before, as they are increasingly the sole breadwinners and also co-breadwinners in their households. As Senator Jackson already stated, the wage gap affects women in every industry, across every occupation, education level, income level. And I'm going to focus just on a couple ways that we think this bill is really important. The first is that it addresses a part of the gender wage gap that comes from situations like Eileen's, where women are not paid the same, paid equally to men for doing substantially similar work or work of comparable character to men's. The second contributing factor to the gender wage gap that SB 358 will address is a widespread lack of information and culture of secrecy about pay that prevents workers from unearthing unjustifiable pay disparities. SB 358 strengthens California's existing Equal Pay Act in several respects. First, it eliminates the outdated same establishment requirement. It clarifies the factors on which employers may rely to pay employees differently for doing the same work, and requires employers to provide more specific business justification for any factor relied upon. And it also requires employers to demonstrate that the justification accounts for the entire pay differential. It provides greater protection for workers who want to ask or talk about their pay or the pay of other employees in order to enforce their rights to equal pay. Just to give a couple examples, the way the Equal Pay Act is currently written has led to absurd results, such as with the same establishment requirement with a woman who was working in San Francisco who compared her salary to a man in the same position in the Fresno office, as she was being paid less than him, and her claim was dismissed in part because he was not at the same establishment as her. So this would allow that type of comparison. Also, ERA has represented women who have, as Aileen has noted, found out, 3 to 4 years into their career that they're not making as much as their male counterparts, and want to be able to discuss this with their coworkers, who also, the men, also think that's unjustified, and they need to know that they are protected from retaliation, and they have that right to discuss that. So SB 358 offers adjustments and updates to California's law that will make it clearer, stronger, and more effective. Given the persistent gender wage gap that is hurting women and families in this state, the time for making these changes is now. Thank you so much, and we urge your aye vote.
Thank you. Others in support of SB 358?
Thank you, Senators. Mariko Yoshihara with the California Employment Lawyers Association. Want to thank Senator Jackson again for her strong leadership on this issue, and Eileen for telling her story. These changes are long overdue, and so we strongly urge your support on this bill. Thank you.
Shannon Smith-Crowley, representing the American Association of University Women for California, and we actually had the wage report, or the college report from 2012 that showed even a year out of college in the same career, there was still a wage gap.
Others in support of SB 358? Opposition? Please come forward. Mr. McKaylee?
Thank you, Mr. Chair. Chris McKaylee on behalf of the Civil Justice Association of California, and we in the Cal Chamber submitted a letter of oppose unless amended based upon the April 6th version of the language. Senator Jackson reached out to us very early, and we have had discussions with herself, and we would like to acknowledge her efforts in this regard and the inclusionary manner in which she and her sponsors have worked on this legislation with us. And I have to acknowledge Ms. Welch of your staff and Ms. Richard of hers in the efforts. Senator Jackson did adopt a number of amendments. We're awfully close. If I could just point you to the bottom of page 9 of your analysis. I think Ms. Welch has done a good job in explaining our position, and again acknowledge that Senator Jackson accepted the substantially similar work. We agree with the sponsor and some of the witnesses who indicated the great limitations on the equal language and the same establishment language, and we share their concerns with that type of language. So that's why we've been amenable to trying to work on this. Secondly, the business necessity definition, which Senator Jackson has put into the bill, we were concerned with the safe and efficient language, which again she has taken out, and some other technical pieces. In the last paragraph, you would note where we do have the one remaining discussion point, and that's the no alternative practice language. What we have done is we suggested language from Title VII for the consideration of Senator Jackson and her sponsors, and in that regard, they use language which places the burden on the plaintiff. In Stender versus Lucky Stores specifically, they use language that the plaintiff, to successfully mount a defense of business necessity under the 1991 Civil Rights Act, the plaintiff may rebut the defense, et cetera, et cetera. So the burden is on the plaintiff. We would like to see the language track how the federal courts have interpreted the 91 Civil Rights Act that codified the business necessity language that was much stronger and placed a greater burden on the employer than the former business justification language. So that's our remaining issue. Hopefully we can come to resolution. We have no issue with the bill moving forward as we continue the discussions with the chair and her sponsors. So thank you very much.
Others in opposition to 385? I was thinking as we're listening that, the assembly rules looks at your past employment when determining what wage that you're going to receive when you get hired as a staff person here. And since this bill applies both to private employers and public employers, creates some interesting discussions that we may
We
have.
have raised that issue.
We may have. Questions of the senator by members of the committee? Seeing none, there's a motion. Would you like to close?
Very briefly, I sit here in equal standing with my colleagues and the people who are working so hard so that we can get equal rights. Finally, we will lead the country in this. I want to thank the folks from the business community. I think they recognize as well that in today's day and age, equal pay for work of what we are calling comparable, what do we call substantially similar work, it's time. It's long overdue, and I'm excited that we're continuing to work together to make it happen. I ask for your aye vote.
Madam Secretary, please call the roll.
The motion is due.
Yeah.
The motion is due. Passes amended to Senate Appropriations Committee. Jackson.
Aye.
Jackson, I. Morlock. Anderson. Anderson, no. Hertzberg. Hertzberg, I. Leno. Leno, I. Wanning. Wanning, I. Wykowski.
Aye.
Wykowski, I.
Let's turn our attention to the issue of privacy. That's 5-1, the measure is approved. We have, in the breach of that, we have SB 570. Senator Jackson?
Thank you. You want to present? Okay. Mr. Chair and members, this is the last bill of the day. I want to thank everyone for their indulgence. This is Senate Bill 570, a bill that will improve the readability and clarity of the notices that are sent to California residents whenever their personal information is thought to have been stolen in a data breach. I suspect many of us, myself included, have received these notices and take delight in the fact that our personal information has been breached for whatever reason. Now, in 2000, and I say facetiously, obviously none of us appreciate getting that information nor having our data stolen. In 2002, California enacted a first-in-the-nation security breach notification law. Since that time, all but 4 states have enacted similar laws. Our breach notification law requires state agencies and businesses to notify individuals when their unencrypted personal information has been breached. This notification ensures that residents are made aware of the breach, allowing them to take realistic measures to mitigate or prevent potential financial losses due to fraudulent activity, to the extent there are measures that we can take. But existing law requires breach notifications be made in the most expedient time possible without unreasonable delay, and specifies certain information that must be included in these notices. The law provides the breach notifications must be written in plain language, but is otherwise silent about how the information should be presented or organized. Unfortunately, fast forwarding since 2002, we have seen data breaches occurring more regularly. We have seen notices often written in a way that obscures the information they contain, making them less effective in communicating critical information to affected California residents. The Attorney General's 2014 California Data Breach Report states that using the Flesch-Kincaid Grade Level Index to assess readability of 770 randomly selected readability assessments shows that the average reading grade was college level in both years, 14 in grade level 14 in 2012 and 13 in 2013. Now we know on average, sadly, Californians read at an 8th grade level, some 5 grade levels lower. And I will tell you, frankly, as an attorney who practiced law for a number of years, I have to read these things over sometimes 2 and 3 times in order to understand them. It's frankly inexcusable. If they were trying to sell you something, it would be in very clear language. But here, there's a real question about whether or not they're trying to tell you and give you information that will be useful to you so that efforts can be made to communicate relevant information to affected California residents. So this bill directs the information currently required under existing law to be presented in 1 page, with the information grouped into 5 headings. What happened? What information was involved? what we, the company or the agency, are doing, what you can do, and then for more information, who you contact. This bill will ensure that businesses and government agencies remain free to provide additional information to supplement the required one-page notice as they see fit. Additionally, the bill makes certain technical changes to the data breach notification law, including specifying that notices conspicuously posted on a website under the substitute notice provision remain posted for a minimum of 30 days, and clarifies the meaning of what is conspicuously posting. These changes will help ensure that critical information pertaining to a breach is communicated effectively to California residents, empowering them to take appropriate steps to protect themselves after a breach has occurred. Now, it won't stop breaches, sadly, but everyone has the right to the best information available when their information is in fact breached. So we have here Samantha Corbin from the Privacy Rights Clearinghouse and Joan McNabb from the California Attorney General's Office to testify in support of the bill and help answer any technical questions you may have if you're still awake.
First witness, please.
I will be brief. I'm Joan McNabb, Director of Privacy Education and Policy for the California Attorney General's Office. And since the purpose of a breach notice is to alert people that they may be at risk so that they can take defensive action. If the notice is unreadable, it's not serving that purpose. If the notice on a website in the substitute form can't be found, isn't serving that purpose. So we support this bill because it helps to make the breach notices that the law requires more effective.
All right, next witness.
Samantha Corbin on behalf of Privacy Rights Clearinghouse, also in support of this bill. Privacy Rights Clearinghouse is unique in its structure in that more than it's an advocacy organization, it's an educational organization. They really do act as the ear of the consumer. And throughout the year, we receive hundreds of calls, emails, and other forms of outreach through our hotline regarding data breaches and how to respond to things like identity theft and a data breach. In fact, Privacy Rights actually puts out a variety of resources because consumers consistently articulate frustration in trying to understand what these data breach notifications mean. So we definitely see a clear need for this bill, and we appreciate the author's effort here. I do know that there is opposition with the bill concerned about how liability would be impacted. Certainly, if you look at the language in the bill, they can still include all of the prolonged legalese pages of it if they would like, just so long as they also include the data breach notice as defined in the bill. That said, again, PRC has years of experience on this particular issue. We'd be happy to work with the author and the opposition to talk through best practices and implementation.
Before we hear from that opposition, is there anybody else who's supporting SB 570? And let's have the opposition come forward and thank you to each and every one of you who've stayed to this late hour with the last bill on the agenda. Please go ahead.
Members, Jeremy Mers on behalf of the California Chamber of Commerce. I'd like to begin by offering our apologies for the late opposition. We did not meet the committee deadline. We think there is a workable solution here. We are currently opposed to the bill as written, but we'd like to applaud two things. First of all, the chair's effort to make this a user-friendly notice, a notice that can be digested by users. I think she stated that in her opening. It's something that's important to us. I think some of the reason right now you see the lengthy notifications is frankly to comply with the current code that is fairly prescriptive in what needs to be in these notifications, and we always are concerned with including too much information so we don't face liability for including too little. The other thing we'd like to applaud the chair for is including the government agencies within this bill. We think that we see far too often with breach notice legislation that they don't include the government, and that in fact government certainly suffers breaches just like private entities. So we feel it's important that if it's good enough for private entities, it's good enough for the government. I would say that the issues remaining that we're looking at are the one-page notification. It's not really clear. There are the 5 subheadings, but it's not totally clear what goes into it. Right now, it's fairly, again, prescriptive of what other information is needed. There's also some confusion as to only whether one notice, this one-page notice, or multiple notices would be needed. We're a little skeptical that we could get all of the information currently needed in the code within the one page, so I think that it would be an additive function. And then we'd want to make sure that, because now there is a prescriptive one-page requirement, that what we do put in that one page, we know what should be in there, so we, again, don't face liability over what's included in this bill. So we think those issues we can work out. We look forward to working with the author's office and with the sponsors. Thank you.
You're welcome.
Margaret Gladstein on behalf of the California Retailers Association. I also commend the author for the things previously mentioned by the witness. The one other piece I would like to add is that we do have concerns about electronic notices and how the one page would work and the readability and font requirements for electronic notices. Obviously, if a notice is produced on a large computer but then read on a phone, how will that work? And we feel like we can work with the author on that, but that is an issue that we wanted to raise to the committee's attention.
Thank you. Next witness.
Yeah, good evening, members of the committee, Madam Chair, Alex Allen with the Bankers Association. We think also that the bill would be helpful if it contained a safe harbor, if we're required to provide some sort of notice that's required by the state and it's very specific. The example for that is for lenders that need to interpret or for the five foreign languages, you have to provide information, 5 foreign languages, that you're able to download a government document and fill out the required fields. By doing that, then you are considered to be compliant with the statute. If we have a specific one-pager that we need to fill out, if it's possible that we can download it and then we fill in the required fields, that we would have been considered compliant with the statute. I think that would be helpful. And then there's just one, I guess some people think it's a little technical thing, but it's respect to providing the 12 months of identity theft mitigation and prevention services. It does right now apply to the private sector. There's a bill going through that would apply to the government sector. There's just two words that were stricken out that says, if any, if you provide this information, if any. Some of our companies actually provide other services that think it's more helpful to our customers, respect to breaches of name and social security number that may not be the identity theft mitigation services, but something that's a little more, we think, useful to the consumer. This one is, at this point, it's optional if you offer it. The language got strucken out, and so we just would like to have that flexibility again. But I agree with my colleagues. We do applaud the author for, I think, putting together something I think we can work together on, and we look forward to conversations going forward.
Next witness.
Rodney Wilson with the California Credit Union League. The Credit Union League has a long history of supporting enhanced data security and data breach notification laws. Unfortunately, for the reasons previously mentioned, we are currently opposed, but continue to work with the author and members of this committee moving forward.
Okay, others opposed to SP 350? All right, let's bring it back 370. Oh, 570. Oh, whatever. 5. Are there questions of the author? Senator Leno.
Not a question of the author. I just thought everything we heard from the opposition you can deal with. And it is unfortunate that the opposition letters were not even noticed in the analysis, but I'm confident that the author will be able to resolve all of these concerns, and I move the bill.
Thank you very much. Yes, this was dated the 24th, and I didn't receive it till the 27th, which was today, yesterday? Yeah. So hopefully we'll be able to put our heads together, and I think this is an eminently doable bill, and I think this doesn't even address how we avoid data breaches. It just gives us information, and I do appreciate, and I'd like to just reiterate that the government also has responsibility here, as does the private sector when we're picking on the government. Both sides in this issue, privacy information, when it's lost, when it's released, when it's made available to others, doesn't care whether it was a breach of government or private sector, it's your information, and we're entitled to have at least some level of privacy, and also to call upon both the public and private sector to take better care of our personal information. So with that, I would simply ask for your aye vote and look forward to working with the opposition.
That element was not lost on the joint author of AB 1710.
I suspect.
If that message needed to be, Madam Secretary, call the roll.
The motion is due. Pass the Senate Appropriations Committee. Jackson?
Aye.
Jackson, aye. Morlock? Anderson? No. Anderson, no. Hertzberg? Hertzberg, aye. Leno? Leno, aye. Monning? Monning, aye. Wachowski?
Aye.
Wachowski, aye.
That concludes our scheduled,
5 to 1.
we have other bills that people need to be added on. I will turn the gavel back to the chairperson.
All right, let's go ahead.
The vote is 5 to 1. The matter is approved.
All right, thank you. And let's go ahead and we're going to lift the calls on all the bills. And please, everyone, stick around for the. Thank you so much. All right. Let's go ahead. Please lift the call starting on file item 10. The vote is 5 to 0. Please call the absent member.
Morlock? Wachowski?
Aye.
Wachowski, aye.
All right, that's 6 to 0. That bill is out. File item 11, SB 270 by Senator Mendoza. The call is, the vote count is 4 to 1. Please lift the call.
Morlock? Wachowski?
Aye.
Wachowski, aye.
5 to 1. That bill is out. The next one is number 13, SB 284 by Senator Cannella. The vote count is 5 to 0. Please call the absent members.
Cannella? Wachowski?
Aye.
That bill,
aye.
that bill is out. Next, we have file item 23, SB 648, Senator Mendoza. The count is 5 to 0. Please call the absent members.
Morlock? Anderson? No. Anderson, no.
All right. That takes care of our agenda. That bill count is 5 to 1. That bill is out, and we are adjourned.